The veteran. Yep. Yep, just us. Nobody wants that middle chair.
No ex parte.
You get assigned duties if you sit in that chair.
Welcome to the public. Since we have no chair yet, we're going to go through the process of approving minutes from a meeting that happened in 2015, which nobody on the board actually was here for, except maybe Miss Duffy. It's kind of strange, I know, but we're going to do that, and then the board will appoint a chair and a vice chair, and then after which they will change seats, and then they will be able to start conducting the meeting at that point. So tonight, since there is no chair, would one of the commissioners like to lead everybody in the Pledge of Allegiance?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
At this point, I'm going to turn the meeting over to the town council attorney for the board, and he will walk them through the process of approval of the minutes and then appointment of the chair and the vice chair.
Thank you. Okay. Thank you, everybody. My name is Brandon Kavanaugh. I'm an attorney at Mangum Wall, Stoops and Warden, and so I'm here not as your usual counsel, which I believe is Gus Rosenfeld, but I'm here so that you have independent counsel as the Board of Adjustment, as then in case any issues that are discussed today actually end up with counsel, then the town's usual counsel will be advising the town council itself. So I'm also here to help with open meeting law and just the process and procedure. As was just said, your last meeting was in 2015, and perhaps only one of you participated in that meeting. So the general approach to that would be as the agenda says, would next be a roll call of the members. If one of you wants to take lead on that, you can. Then you would go into approval of the minutes, and then you would go to what normally happens as the first meeting after July 1st of a year, since your officers generally change on a yearly basis. You would then go into nominations and election of a chair and a vice chair. And then that would be, after that election, the person that's then going to be running the meeting from that point forward would be the new chair. And at that point, we can get into the other issues that are still on the agenda once you get that far. But with a situation where you don't have a chair yet, you could either default to the past chair, which in this case, since it has been since 2015, that might also not be practical. And so either you could default to the last person that served, or you could choose somebody that is willing to volunteer to lead the first couple of items until you have the election.
Would the first couple items be basically approving the minutes of the last meeting? And well, I think I might be comfortable in approving the minutes of the last meeting, so I could take the lead on that.
Okay.
Good idea.
Anybody else have any objections with that?
No.
No.
Then the minutes can reflect that that Beverly Duffy is going to be the acting chair of the meeting for the first few items on the agenda until the election occurs. So the first thing would be if you wish to call a roll call, ma'am.
Okay. Roll call for Board of Adjustments. I'm Beverly Duffy. Do I give my address or?
You don't have to. You
Okay.
can just say acting chair.
Been acting chair, been in Chino Valley since 2006.
And Billy James, been in Chino Valley all my life.
I'm Julie Northington, and I'm here a year and a half.
I'm Sandra Tutabeni, and I've been here since 2017.
Mike Duda, and I've been here since 2018.
So with that, you can move on to approval of the minutes from the past meeting. If you wish.
Okay. I move that we approve the minutes of the last meeting that occurred on August, what was it?
April 21st.
April 21st, 2015.
Move to approve.
Second.
Do you have any discussion?
No discussion.
No discussion.
Then feel free.
Okay. Motion has been moved and seconded. All those in favor, say aye.
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 Motion has been approved. The minutes have been approved. Next. What's the next item?
The next item, ma'am, is the potential election of chair and vice chair.
Okay.
I nominate Miss Beverly as chair. Given your history and longevity and knowledge of this previous committee meeting.
I'm curious, Julie, because I was going to nominate you.
I'm Sandy.
Sandy, I'm sorry. That's how new we all are. But I would like to defer. I do not wish to accept that nomination. So, is there anyone else who would want to? Would you,
I'll nominate Beverly.
Sandra?
I'm
Sandy.
Sandra.
I second that nomination.
I'll accept. Let's move
Okay.
on.
Okay.
All those in favor?
Aye.
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 Sandra Sandra Tutabane has been approved as our new chairman of the board
All right.
of adjustments.
Thank you. So, Ms. Tudabene, if you would be interested in running the nominations for a vice chair.
Yes. Anyone would like to volunteer to be vice chair?
I'll volunteer as vice chair.
All right. Thank you. Everyone okay with
I
that?
second that.
Okay.
I second. Or third.
Beverly is vice chair.
Well, if we could have a vote.
Oh, a vote, please?
Yep.
Aye.
Aye.
Beverly is so nominated as vice chair and
Okay.
elected.
So the next item on the agenda is the public hearing regarding the appeal of the interpretation letter.
Yes, the public hearing. So, having watched several other board meetings, at this point, I assure someone is to get up and give their opinion, whether it be the applicant or yourself, Mr. Cook.
Yes, typically staff gives their staff report or
Alright.
comments, discussion, and then the public hearing is open for public comment,
Okay.
at which point anybody in the public that wishes to comment either for the appeal or against the appeal is welcome to get up and speak. The chair is entitled to specify a certain amount of time that people are allowed to speak in order to help the meeting move forward. Whether you do that or not is in your purview. Staff doesn't necessarily have any recommendation one way or the other there.
Well, to be consistent, if you all agree 2 minutes, that's what I've seen at other meetings. And we have this lovely timer. 2 minutes it shall be if everyone's in agreement.
Fine. Fine.
Typically it's 3 minutes.
Oh, 3 minutes.
Um,
This timer doesn't tell me.
I think we have a timer. I don't know if we have access
Is
to it.
that it?
It's usually
The official timer?
If you wish, I can use my cell phone if you want.
That would
Stopwatch
be
on it.
lovely. 3 minutes, then thank you, 3 minutes.
I don't have a presentation as such. I just have a few things to comment on. You have had ample time to read the interpretation letter as well as the appeal. You've had ample time to read the zoning ordinance, what the code actually states. So just a few points to mention. First, back in May at study session, council study session, I brought up the fact that the current sign code does not include language in there that would allow us to renew sign permits, temporary sign permits. I asked for some time to change that code, to go through the process to change that. Tom requested an interpretation. Mr. Payne requested an interpretation letter. I provided that, and it has since been appealed. I will mention that staff cannot interpret or enforce the UDO based on intent or past actions of staff if it's not written in the code. This could and would be seen as arbitrary and capricious. I am required to enforce the code as it is written. I cannot put my own beliefs or understanding into that. This interpretation does not mean I don't think that the code should be changed to allow temporary signage, but this isn't the place for that. That is a planning commission and council action. And my staff interpretation was based on what was strictly written in the code. That is all I have to go by, and I can't make my own interpretation and belief what it should be. With that said, staff recommends that you find that my interpretation is correct. Obviously, I wouldn't recommend anything else, which is kind of odd. So if you want to turn it over to the public to let them speak, and then after the public speaks, when you're ready to close the public hearing, you have ample time to discuss it among yourselves, ask questions, and then make a decision.
And during that ample time, do we do that privately?
No, there is not an executive session on the
Okay.
agenda, so there is not the opportunity to vote to go
So-
into one. This will all be in public session.
Okay.
You do have the ability to ask questions, and if you want to ask me questions, I will answer them as best I can, noting that since there is no attorney-client privilege in open session, I may answer them a little bit differently than I would in an executive session, but I will certainly answer questions as best I can to help you.
Can we ask
Figure out where
questions
to
to
go.
the public when they are speaking?
You can, there needs to be a limited approach as to what you are deciding you're going to do. So if, for example, you decided to have an interaction with the person filing the appeal, that would be different than interacting with each person that is standing up to give public comment. So generally in a council meeting, if you had public comment, you would not interact with the speaker. But here, as this is an appeal, you certainly have the ability to interact with the appellant, and you also have the ability to interact with staff as the ones presenting their positions in front of you. So hopefully that helps give you some idea of the way to approach this.
Thank you. Does it help?
Yeah.
All right. So we are going to open this up for public discussion. Anyone like to speak?
Hi, my name is Tom Payne. I have Tom's Print Sign here in Chino Valley. 3 minutes to make a case against a situation like this for an individual speaker is not an adequate amount of time. Honestly, there's no other person here that was prepared or expected to speak. This is a one-item, one-issue hearing. I would appreciate a little bit more time to have discussion about it and to make the case. If not, I believe I can get people to donate their time to me, but this is all we're here for, really. I spent a lot of money to get here. I spent a lot of time in a prep to get here. This is very important to our community. It's really more about them than it is about me. And I don't want to cut things short just so we can be, short.
If questions are asked, that won't count against your time.
Um,
So present what you can. And
Chairman, to Benny, if Tom is the only one speaking, I would say allow him as much time as he wants.
That's what I was going to get at, exactly.
Thank you, Mr. Cook.
Thank you.
Let the record show that a document has been added to the record.
Here, I'll give you, gentlemen.
Thank you.
All right. So first, I wanted to start with a little introduction, just so you know that I'm not up here as an angry citizen or whatnot. I have been a longtime member of this community. I've been in business for myself for 28 years, Chamber of the Board for the Chino Valley Area Chamber of Commerce for 6 years, Board President for 2. I've been on multiple sign committees since 2009. There's been 3 of them that I've been a part of. I was on the General Plan Committee, got my little key to the town of Chino Valley a couple years back, like the nice gal did at the rodeo the other day. Rotary Club of Chino Valley for 10 years, Club President. Lions Club of Chino Valley for 10 years, Club Vice President, Lion of the Year. We were Chino Valley Business of the Year in 2009. So there's a long history of dealing and working and volunteering and helping out the town. You can see the philosophy there that's on display in our office from Proverbs 22. That is exactly what Wendy and I believe. A little history on the temporary signs in Chino Valley. In 2008, the countrywide financial crisis hurt all businesses across the country and town. Highway 89 road construction at the south end of Chino Valley caused businesses to struggle in this already challenging time. Mayor Jim Bunker formed a sign committee to come up with options, a committee that come up with options to provide relief and better visibility to businesses. We created a 1-year temporary ordinance. It was going to expire, and we had a new mayor. Chris Marley was on the job at that point. He met with community members and the town, and they saw the positive benefits of the ordinance that we had passed previously. So they renewed it. There's another temporary version, and we did that so we can do a full rewrite. In 2016, we had great community outreach by the town and support from the citizens, and the new code was adopted. This week, the newspaper had an article saying the town was enforcing the code to the letter, and the opposite really is true. I want the code enforced to the letter. I try to live according to a higher code. Deuteronomy 4:2 is appropriate, and it says, "You shall not add to the word nor take from it." Sign permit fees are adopted by town council by resolution. The town of Chino Valley fee schedule lists temporary signs per month at $5. It does not say $5 per sign per month. It never has said that. Signs is also plural, you'll notice. Temporary signs are $5. The situation is the same with permanent signs. Mr. Cook unilaterally added additions to the council resolutions in his letter to me. Below is what previous applications have said before it was changed. It is and always was an application fee, not a per sign fee. So the first chart there with the yellow highlights is what the fee schedule says for the town of Chino Valley. And you can see there it says temporary signs per month. It does not say per sign. It says per month. Okay. You can see in the second one that I put in there that application fees, sign permit fees require a fee of $100. Temporary sign permits require a fee of $5 per 30-day period. Application fees, this is the second one off a previous sign permit application, and it says the same thing. So this is the precedent, this is the history, this is what it's always been. In addition, the code says signs are figured on an aggregate basis. Everything that is permitted has always been the same application fee, $5 temporary and $100 permanent. It even used to be on the same form. You just check temporary or check permanent and you fill in the same boxes. Until I pointed that out, and the solution was staff changed the applications to say per sign. Now, changing and adding to what the council has adopted is not the way I would have went about it. So he's the one that added the words. I am and have always been for going by the letter of the ordinance. To the next issue is, are temporary sign permits renewable? Yes, they are. Mr. Cook's reasoning in his letter that the ordinance doesn't say temporary signs are renewable is misguided. We have long-standing precedents that every other permit or thing that is for a set period of time can be applied for again. Everything from driver's licenses to car registrations, magazine subscriptions, conditional use permits, et cetera, can be applied for once one expires or if additional work is needed. None of those have in the ordinance describing, say, that you can apply after the first one expires. Probably not, because it's common sense, or probably because it's common sense. If one meets all the requirements in the current code, then your permit should be granted. If the ordinance said this is the one and only time you can ever get one of these, okay, we wouldn't be here, but it doesn't say that. It has always been intended to be renewed. Again, I was part of the committee with previous staff when we wrote this ordinance. I'm very, very familiar with it. We completely intended it to be renewable as it always has been. Below is a letter written by Penny Hubble of our local State Farm Insurance Agency, as she was on the last sign code committee. It's also signed by 3 other committee members. And it reads, in July 2016, several business owners, including Tom Payne of Tom's Print and Sign and Penny Hubble of State Farm Insurance, sat on a sign ordinance committee. We went to great lengths to simplify and clarify the retired sign code. Specifically, the temporary signage clause 4.21.2F was discussed but not changed for the convenience for town staff and business owners. Discussion focused on the need to keep it simple, reduce the number of times the town and business had to interact for renewals. Therefore, we all agreed 6-month renewable permit was most advantageous for everyone. At the end of 6 months, the business owner had to reapply, which encouraged sign maintenance and gave the town an opportunity to deny a permit if the temporary sign was not maintained. State Farm's need for temporary signage was specifically important because the office is set back from the road, easy to miss, provided a way to promote our products and services, especially those corporate insist they promote. We hope this language to grant the 6-month permit and the committee's intention for it to be a renewable permit would be honored, signed by 4 of the committee members. That's Penny Hubble, Jim from the barber shop, Gary Denny from El Charro Norte, and myself. Further below is part of the town staff's information packet to council on the outreach they did. Temporary sign permits can be renewed. So part of the process that the staff did was, as people came in to apply for sign permits or renew temporary sign permits, they asked them about the future sign code and what they wanted to see and what would be helpful to them. So you can see right there that part of staff's outreach was talking to people as they renewed their temporary sign permits. Finally, consequences, just so you understand where businesses and organizations come from, they rely on these temporary signs, and it's hurting. Businesses down, sales tax is already higher than our neighboring cities, and local businesses are losing sales. Local churches and organizations are not able to make people aware of events like they have previously. Drive through a neighboring town, you will notice all the banners and feather flags, because other communities that we are competing with are advertising this way, and we can't. We are at a second disadvantage. Sales tax revenue in Chino Valley means more services for our community. The senior center, our parks, the pool, all benefit from this revenue source. Lower cost temporary signs benefit the mom and pops. Large corporations have no issue with large sign budgets. In my 28 years of helping the little guy chase their American dream, I found that small businesses can utilize affordable and effective temporary signs is critical. And finally, from another town staff report to council, I'll just read the highlighted part. Terminating the temporary suspension of prohibitions on certain types of signage set forth in this ordinance will likely have a chilling effect on business. We really don't want to hurt business. We don't want a bad-looking town either. That's why businesses are the ones that suggested the 6-month time frame, so that we can it makes the businesses buy in. They're not going to go down and spend money on a permit for a sign that doesn't look good and represent the town well. They have to pay attention to it. They can't just stick it out and leave it, because we now have code enforcement that could come and say, it also gave staff a chance at the 6-month period to review and to say, I drove past it yesterday and it looks poor. We're not going to renew your permit unless you get a new sign. It was a great compromise that the town staff and the committee members and businesses and citizens that were on it came to try to keep our town looking good, to give town staff the tools. The sign code already states that if there's anything in poor misrepair, that code officer can remove it. That's pretty much my presentation. I'd love to answer any questions.
I have a question for you.
Yes.
Why is it that your appeal letter says that I want to apply for a new permit when your dialogue is specific to renewing a past permit?
It's both, and it could be totally both. It depends on what is needed for that individual. I don't put up a flag all the time. Sometimes I put it out, sometimes I don't. More established businesses don't really have to do it. But so I have a new product, I want to go get a new permit. It's not really renewal of an old permit, it's a new permit. So a permit is good for no more than 6 months. We've called it renewal in the past, but it's really a new permit. And when you apply for a permit, as long as you meet all the requirements of the code, you should be granted that permit.
And another question, is there a reason that you're not bringing in the 2017 ordinance that dialogued the reason why this specific chapter was updated and the presentation of Reed versus Gilbert, Arizona?
Yeah. Reed versus Gilbert was a very challenging time in our life because that was a big part of it. And we ended up trying to reference and tried to take that into consideration so we could be proactive for it. And it turned into a big nightmare because it was still tied up in courts. It's gone back and forth a few times, and it's still a little bit confusing. It really doesn't impact our temporary signs in this instance. There's no content that's being regulated or whatnot. It's just basically that the sign code says that a sign permit will be good for no more than 6 months, and Mr. Cook has interpreted that to mean that it's a little confusing actually, because the first time we were thought it was you were allowed 6 months out of the year. And then when we got the letter, it's clear now that it's 6 months period, and that's the only time you can ever get a temporary sign permit, which is really hard on a business that could utilize these things and help out our businesses and help us survive. Some of us here today are really, really struggling with the downturn in sales because people don't know they're there. There's been several businesses in the community, Chino Glass is one of them, that people just thought they went out of business. They had to take down their flag, and people like, oh, they're gone, I'll go somewhere else. The barber shop was the same way. The flag is now gone, okay, I'll go to a different barber. And so their business has been hugely impacted. And that's such a shame. It doesn't have to be that way. It shouldn't be that way. It was never intended that way. It's never been enforced that way. I'm not a lawyer. I'm an ink slinger for all intents and purposes. I don't know what, but it's pretty much plain and clear there as far as I can see. It doesn't say per sign, and it does not say that I cannot get a new permit.
So I have a question. So I should say this. What does the word temporary mean then?
Temporary is something that is made out of a material that is not long-standing, and it's not permanently affixed. So
Exactly.
most of us put our signs out in the morning and take our sign. I won't say most of us. A lot of us take our signs out every night. There's no point in advertising at night in Chino Valley, right? I mean, it's dark. Nobody's out anyways. We roll up the sidewalks. So advertising it, so it's temporary in the fact that it's not permanently affixed. It comes
So
in
you're
at night.
just using it during working hours.
Just using it during working hours. There are some people that put them out and completely ignore them, and they wear out faster. The wind blows all night long, and it tears them up, and they don't last very long, and they get stolen. Another thing people say, well, of course, Tom, you're interested in this because you sell signs. I could sell a temporary sign for $80, or I can sell a permanent sign for $800. I'd rather sell the permanent sign, but the temporary sign helps the businesses. And most of them that we're talking about here, we don't make. We just don't. They're generic. It says barber. You can go on Amazon. They sell those things. They bring them in by the container from Chino. I don't make those. I'm not here for Chino. That's why I gave you my little introduction. It's not about me. I don't make most of those signs that say breakfast or open or whatever. That's not my bag.
What is the new product that's so different than what you are promoting that you've had as your temporary sign from before?
Okay. I get bored, so I like to introduce new things, much to my partner, Sister Wendy's chagrin, because I've got a whole table full of them in my lobby that people come in and say, hey, that's cool, how much is it? And I say, I don't know, because I haven't even priced it out yet. But since we've been opened, we've been opened in Chino Valley since 2008, so there's been new products throughout the years and new things that we need to tell the community about. I can't tell you how many people pull in because they see our blueprint sign and go, oh, thank God, I don't have to drive all the way to Prescott. I can get back onto my job site an hour plus faster because I can get my blueprints made here. You do shirts. We picked up a huge client because they saw our shirt flag, and they've got 4 offices in neighboring communities, Bullhead, Kingman, Prescott, and Phoenix, and they pull in for shirts, and now we've sold them 200 T-shirts. We've done 12 different vehicles for them. It's been a huge revenue source for us, as well as sales tax revenue for our community that we now have because of those things. We don't have them now. The other new product is sublimation, and come check it out because we can pretty much print on anything. Socks, cutting boards, wood, glass. Glass is cool. You see those things online all the time where you print on glass and you look at it. It's really phenomenal. Come check it out.
So are you petitioning this for your own personal business, or are you doing this for other businesses through town?
This is an issue I believe that affects everybody. I'm just the one that's most familiar with the process and the history of it. And so I got nominated when I was on the general plan committee. Dava came in and she kind of ran that for us. And she says, okay, you're planning the entire direction for the entire town and what everything should look like. And if you don't stay involved, it'll get changed and it'll get flipped and it won't be what you guys are envisioning and what the community will vote on. And so it's important for you guys to stay involved. I'd like not to be involved. I'd really like to go home and pet my dog and be done with all this. This has caused me a lot of sleepless nights, a lot of time. And every time I argue this in my head, I've won. So I'm pretty confident that we're good here.
Mr. Cook, question. Regarding his information was any verbiage changed from the ordinance written that he claims some verbiage was changed or the month, per permit, blah, blah, blah,
I provided you the exact language that was in the fee schedule as well as in the code.
Okay.
I am not aware of any change in language. The fee schedule states land use signs, temporary signs per month, $5. It doesn't say per application.
Does that state in there, because I was reading it, I don't see anything where it says that, is that 6 months per year or 6 months for the life of the business?
This is where the confusion comes in. It says the exact language. In the temporary sign section, it doesn't identify material as the reason it's temporary. It just says temporary sign permits shall be issued for no more than 6 months. That's it.
So the literal interpretation is one bite at the apple.
That's what the code says, which is why I told the council that we needed to change the language. If it's the council's understanding that it needs to be allowed to renew on a revolving door, although there's some debate whether that's actually temporary or not, then the code needs to be changed to reflect that. So it's easier to understand, it's easier to enforce, there's no question, there's no need for a Board of Adjustment hearing on an appeal to an interpretation. The code, regardless of what happens tonight, the code needs to be changed to reflect the council's will on what needs to happen regarding temporary signs.
Question for the applicant.
Yes, sir.
The term renew has been used. When you go down, do you fill out a new application? Or
Yes.
do you just
No. New application.
new
So then
application?
it's not renewed, yeah.
Thank you.
And Mr. Cook, how many other businesses has made such a claim, if there have been any, in the town?
claim for,
regarding a renewal, or what Tom is Mr. Payne's trying to do?
well, there have been several businesses, I don't know the exact number, that have come in asking for temporary sign permit.
What,
I just want the code to reflect what we want.
what's
and
the time frame? Should the verbiage be changed by the council, by the town planning? What is the time frame?
Well, staff has met 4 times with town council UDO members, Unified Development Ordinance subcommittee members. We've met with them 4 times. We are now meeting with the town council this coming Tuesday to discuss the changes to the temporary sign ordinance. So hopefully we can get that moving forward quickly. As soon as the town council is happy with the language that is proposed, both through public input and staff input, we'll take it to the planning commission, then it'll go to council, and then there'll be a 30-day appeal period, at which time it will be ratified.
Following your argument that the 6 months temporary, looking at the prohibition, 4.21.7, any sign not specifically listed as permitted by this chapter is prohibited. Taking the literal stance on that, I'm not able to find a definition for a permanent sign other than a plethora of what signage looks like, how big it is, how broad it is, what the illumination is. So if there is a deliberate definition of temporary signage and it's of 3 flavors, 2 types of banners and 1 A-frame, what is a permanent sign?
The permanent signage is defined in the section of sign standards, which talks about wall signs, freestanding signs, awning signs, electronic signs.
Does it
These
indeed
are,
tell me that these are types of permanent?
that is correct.
Please point me to that section.
Explain your question exactly.
Well, I see a definition for temporary. It's specific. It's F. And all
Correct.
other signs then defined under the section of permit required are considered permanent,
That would be correct.
but it's not explicitly stated.
No, no, ma'am.
Thought it was under a subsection. Because it breaks out temporary signs after that.
No, there's a section, it's section
There it is.
4.21.1 is purpose. Point 2 is permits required. Point 3 is general sign regulations. Point 4 is measurement of signs. Point 6 is temporary signs. Point 7 is prohibited signs.
But no permanent,
Permanent or temporary is not defined, actually.
correct.
Oh. So the question was about adding words to the ordinance. If you use Mr. Cook's letter that he's provided of explanation, you can see the fee schedule and compare that with his letter on the back page or the second page. I've highlighted in green here. He added per sign. He is designating it per sign, where the fee schedule clearly does not do that. And that's his letter.
Again, it says land use signs, temporary signs, $5 per month. That's the exact language.
Right, and in the ordinance itself, it speaks to signs being taken into consideration as aggregate. Aggregate is a collection of whatever's there, turned into a whole. And as I showed you in the other presentation slides I put in there, it's always been an application fee for whatever you're allowed. And he's changed that now on permanent signs too, which is going to be interesting when people find that out, that now, according to the new sign permit, it's now $100 per sign. It's never been that way. Nobody's ever interpreted that. Nobody's ever tried to interpret that. It's Mr. Cook's been here since March, I believe, and he is coming in and trying to change it or whatever, bring us into the big city, the modern age or whatever. But to make a small business that is just a gal with a flower shop that wants to try and sell a couple flowers, or a dog groomer that wants to go on and on their own and have to pay $100 per permanent sign, which I define as anything permanently attached. It doesn't come down. It's bolted to the wall. It's bolted to the ground. It's bolted to the side of the building. Those in my mind are permanent signs. But to make that person have to pay $300, $400 in just permits, not including the sign. Technically, the sign could be a $20 sign that they want to put to the sign to the side of their building, and with Mr. Cook's interpretation of that, it's going to cost her $100. The sign's $20, but the permit fee is $100, and that's just wrong.
So are you asking that under a temporary sign, you pay the $1, $5 fee for 6 months? Does that mean you're asking to be able to put up a sign that says shirts, and then a sign that says blueprints, and a sign that says cups, all under that $5 permit fee?
Generally, no. Generally, you're supposed to provide a copy of your sign copy to the staff so that they could look at it, review it. I know with Reed versus Gilbert, they're not allowed to actually read it, but it's just part of the process. You have to provide them a copy of the sign. And so no, I change mine up occasionally at the month breaks, basically, because it just catches eyes better that way. It's more effective.
So you're saying then that $5 permit for the temporary sign, you would take one temporary sign down and replace it with another temporary sign within that 6-month period?
Within that 6-month period, yeah. Sometimes that happens. Not generally, but it just,
So you would never have like 3 signs under that temporary sign permit?
Not at the same time.
Not at the same time?
I change mine monthly, if I even remember to put it out. Honestly, this is more about new businesses and not established businesses. You're never going to see Dave Mazie put out a sign. You're never going to see Sonny Stasinski put out a sign. It's just, Steve Forbear doesn't even have a sign hardly at his transmission place because they're established. This really helps out people that want to put out new products or people that are just trying to, get established.
So,
Miss-
I'm sorry.
Mr. Cook, is there a limit on applications for temporary signs?
We go by the letter of the code, which says they're allowed to submit for 6 months.
4 in a
temporary signage.
6-month period?
Mhm.
So your application, does it include the bevy of different signs you may be switching out on a monthly basis during that 6-month period?
No, generally I have 2 signs and I just rotate them, and they're both on the permit.
They're both on the permit. So making an application for another permit, you would introduce other information?
Likely,
On-
yes. Some different organizations would have a different outlook at that. I can't speak for them, but just like the church wants to put up a banner for their Easter program, I'd like them to be able to put out their banner without having to run down to town and ask them for permission. If they want to put out a vacation Bible school, we need things for kids to do. I'd really like to see them be able to do that. We're a small town that's starving for entertainment and for things for our kids to do, and for products that keep sales tax here rather than going to the big cities. And maybe we could keep our pool open another week or something if we had more sales tax revenue. So the more we can do for our community, the more my kids get to swim.
I'm not sure I understood that.
Okay, so
Are you saying you don't want to have temporary sign permits?
I do want to have temporary sign permits because that allows me to advertise products. And when I sell products, 10.35% sales tax is collected on that, of which our city gets 3, I think. So 4. So it's a benefit to our community.
So the church can pay $5 for a temporary sign that says Bible study on for the next 6 months, right?
They could. Sure.
Right.
So we aren't prohibiting people from putting up the banners with a $5 permit.
Per month,
Presently,
for up to
yes.
6 months.
Yes, it used to be when it was really tough. We've worked really, really hard, and I've been part of this through the chamber and just community involvement to fix our business unfriendly reputation. If you talk to contractors or you talk to anybody that tries to do a lot of stuff in here, we've had a really business unfriendly reputation, and we've worked really, really hard to fix that. Our direction with the old sign code from the person that was in Joshua's position before, 2 people back, was to simplify it, to make it as easy to read and understand and as common sense as possible. And that was what we did, and we all understood it until Mr. Cook came to town and said, "You guys are wrong." And I've got a different opinion.
I would disagree with that. My 2 predecessors also felt that there were issues with the sign ordinance, but they didn't address them because
Yeah.
they were here temporarily.
Jason, the interim guy, and I had the same conversation in 5 minutes. I've got my $5 sign permit because he agreed.
I don't blame Mr. Cook for
No.
interpreting this as being new myself, and I am interpreting it almost the same way as he is too after looking at it. But I understand your stance on this, and I understand being a store manager here and understanding my signage that I needed. I understand where you're coming from on this. I think that the council needs to come into this and add some other stuff into it. Is limitations on how many signs can go up, limitations on how long they can go up, if they're tore up. We don't want our town looking trashy as you're driving down it with all these flags or whatever tore up. I mean, we live in a windy city of Chino Valley, and that wind can do damage on a lot of these signs, especially if they're temporary signs.
Yes, and that's all addressed in the code. We absolutely took that all into consideration. The town staff previously has a full page of outreach that we've done through the newspaper, through the chamber, through businesses, through communities, through forums, through committees, and we've addressed all of that, and this is the direction that we want. I've got 20 pages of 14 signatures to a page that people are in favor of signage. They use it for landmarks, they use it to find their dentist, even if they're, see the barber flag. This is very important to the community. They've spoken. The council actually unanimously approved this. Everybody that's on that council now was either on planning and zoning or actually on council when this was voted in, and it was perfectly understood by the 4 businesses I listed that were on the committee, as well as everybody else that was working on it at that time. We used to have to go in every month and pay a $5 permit fee for our temporary signage. And then thankfully, we realized that that's not a very efficient time for staff. That's not a very efficient use of a business's time. And so we're going to extend that so we don't have to do that every month. Actually, at one point, we took it to a year. If I've got all the source material here, if anybody wants to see any of it, we had it we could put up a temporary sign permit for a year. But at a point throughout the process, we decided it's windy here. Signs are not looking good, and people aren't paying attention, so we've got to help them pay attention, so we shortened that. But to have to go back and do it every month was ridiculous, so now we want to go back and do it every 6 months, and so that's the way we wrote it, and that's what was perfectly understood by absolutely everybody there that was doing it at the time. I mean, it was long discussed. It wasn't just a matter of
Well, everybody's perception's a little bit different.
yeah,
And
that's-
so be thankful that Mr. Cook came in and was able to perceive this way, in his way, perceive it. And so it can open our eyes in order so we can fix things that are perceived differently.
Any other questions? You have a question?
somebody from the public requested to speak, and
Okay.
and then
I'm
I.
going to have to
It's,
step in on that. You were agreeing that you were going to take
Okay.
time by nobody else speaking.
yeah, I understand. That's why I'm not an attorney.
For us. Any other questions, ladies, gentlemen?
No.
Not really? No. Okay. Now,
Are we allowed to take a recess? Or?
You can take a recess as long as it's not to discuss this matter, but if you just want to take a recess as you want to break,
No.
then you would come back and have your discussion in public session.
So we can have a discussion in the public
Yeah.
Right now.
concerning this.
You need to have your discussion in public, yes,
Okay.
in a public session with minutes and or recording, but you can take a break if
Okay.
you wish to have a break at this point.
I would also add that if you're done with public comment and questions and you are ready to discuss among yourself, the proper procedure is to close the public hearing and then to proceed with your board discussion and then motion and one way or the other.
Okay.
That is correct.
So I move that we close the public session, no more comments from the public, and that we begin our discussion.
I second.
Approved. Okay. We need a vote. I thought we just did that.
No, I
No,
just seconded,
seconded.
now we say all. Oh.
All in favor, say aye.
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 Aye. All opposed? None. Okay. Okay. So, as I interpret the appeal says, I desire to file a new temporary permit. I don't have privy to the June 13th, 2019 letter, which started the correspondence. In the appeal zoning administration interpretation, I pulled up and reviewed all of the different statements that were provided as a staff report. Prohibition of signs. Any sign not specifically listed as permitted is prohibited. And it lists including but not limited to. And I already asked the question, what about permanent signs? We know what a temporary looks like. I also see that in March of 2017, that the board decided to rewrite this specific chapter based on concerns related to Reed and the town of Gilbert, in as much they wanted to be sure to encourage economic development of the town while protecting public safety and preventing the negative impact of clutter and unsafe placement and construction of signs. That too is also listed in the very beginning of the land usage statements. Number of purpose, subsection B, promote economic vitality for local businesses and services in the signage regulation. Number 2, in part of the staff report, the rationale indicated that if it is not listed under the temporary signs, we cannot approve it. And the statement is that temporary signs, when you read the subsection 421.6, it gives you a listing of 3 flavors of signs: banners and pennants, square footage, and an A-frame size limitation. Doesn't define what a temporary is other than the type of product. And lastly, under number 3 of the reasoning behind the determination in the staff report, is that temporary signs with a limit of duration of use, such as those provided in the section I just defined, which is 21.6, obtain a permit, and that they shall be issued for no more than 6 months, and they shall conform to all other requirements of this code. As I'm reading this, I have questions as to a single bite at the apple based upon trying to help the community thrive economically.
My interpretation, as I asked Tom, he fills out a different application every time. Each application is only good for 6 months, clearly defined here. It does not say that I can't go back and get another permit, which he is now filling out new. The renewal part was a little bit confusing to me. That's why I wanted to make sure. So following this, a temporary sign ship permit shall be issued for no more than 6 months. At the end of the 6 months, that permit that you requested is null and void. You now may fill out another one. Because nowhere in the UDO or anything else that says that you can only have 2 in a year, 3 in a year, it says each permit is only good for 6 months. So that was my interpretation. Also, the fact that it says sign, so in my interpretation, goes along with the applicant, you might want to change out your signs there. So if you change out a sign, you have a temporary permit, not necessarily defining each individual sign. So as long as it follows the definition of a sign, but not the exact picturesque wording of the sign, it's still good. Following your church thing, perfect example. You have an Easter, you have Vacation Bible School, all goes under that same permit because it's temporary. Doesn't say that each one has to be defined.
The question I have is that $5 permit, in places I'm reading that permit is good for 6 months for $5.
No, $5 per month.
Other
It's-
places it's saying $5 per month for 6 months.
Per month.
Is that an issue with the applicant, or is that at,
I was unclear because he
Yeah.
said they tried to change it, and every month he was going in, it was cumbersome for the council or
Yeah.
for the town, and then on the other hand, it says that he paid $5 for the 6 months. So I'm
Yeah.
still a little unclear on that.
See, and I believe an applicant who fills out an application and submits the required statement, whatever they want to put up, wing, wang, ding, dang. Wing, wang, ding, dang, you get it for 6 months. If you want to change it to LMNOP, you apply for another temporary signage, and then you put up LMNOP. But you don't change it on a weekly basis because your application has to have the scope and the nature and the detail of what is being done. And how you pay your $5 a month, if you write one big lump sum, fine. If you want to come in monthly and pay your $5, but it's 6 months.
Yeah.
And if you decide after 4 months it's ripped, you still signed a 6-month contract and you can take it down after 4 months if it's no longer a viable tool.
I really feel that we need to, something needs to be stated on the condition of the permit, or the signs, sorry. I'm really big into keeping town Chino Valley nice looking, and I've seen some of these signs look trashy, and even after 6 months, after 2 months, you know? And if we're gonna do that,
I
they need
believe
to
it's
be,
in here that it has to be kept in
it needs to be an ordinance on
required
it.
condition, so if they're ratty, that would be up to the city inspectors. Code
Exactly.
enforcement, Not
To enforce it, yeah,
I mean, people are gonna try to get away with whatever they can.
exactly. You
And you're
can,
paying a permit fee, which actually goes along to code enforcement.
exactly,
So the code enforcement, if the signs are there, it's already defined in here.
yeah,
Yes, and there is a requirement to monitor the quality.
or the quality of it, yeah.
If I may, I also would like to note for you from a legal perspective that it's relatively rare that you would have a general interpretation being appealed, because as the Board of Adjustment, you sit on a particular applicant's application, and then you rule on the facts of that particular applicant's application, whether it fits the requirements, whether it doesn't fit the requirements, whether the appeal is appropriate or not. So it is legally very odd that you would actually have an overall interpretation policy being brought to you as an appeal. Because as a number of you have noted, an overall interpretation policy is really what the council's job is. And if people want to have a change in the overall interpretation, that really is something that the council is supposed to take into account as they take their legislative action to decide how they want to handle any potential way that somebody might come in looking for a sign. And so as the Board of Adjustment, you are generally sitting here in the role of saying, this sign, this day, this application, this description, this use, this material, does this or does this not fit the requirements that the code has as it exists. And so I do want to note that for you as well, that you have an interpretation in front of you as opposed to any particular sign and any particular application.
That's why it's kind of difficult for us up here to, we can give our interpretations as Mr. Cook has, but how do we move forward to conclude this discussion regarding, do we make a statement saying that the council needs to update the permit information? Or does Mr. Payne's application be passed because this is the wording? We don't, how do we vote? Do we vote? How do we proceed?
Well, if you were to actually determine that the appeal is or is not successful, then you're going to have a vote on that. If the appeal is unsuccessful because you believe it's the council's job to handle these issues on an overall basis, then that might very well be your motion and your decision. If, on the other hand, you have a decision that you want to effectively grant the appeal of the interpretation, then you have an open legal question of whether you have any authority to substitute your interpretation in place.
I don't think we would need to go that way, because I'm not sure if we're qualified for that.
Well, and that's exactly the point. So that's part of why this is an
That's why
odd
we're here.
request.
No, I thought that's why we're here. It went between that person and that person, and now it comes before us to make a decision.
That's what I
If
thought
you
too,
wanna
yeah.
back off because you don't feel qualified, then
No, I
abstain
don't,
from the
I,
vote.
No,
I
no,
don't want to
if-
back off on that.
if-
I
if-
want to
I'm just
make sure
saying.
this is legal, that if we make a motion tonight, is that legal for the town to follow?
We make a motion on behalf of the applicant,
Okay.
and that applicant is Mr. Payne. And reading his letter, we make a motion on his desire to apply for a new temporary permit.
Technically, that's not completely accurate. There's several motions you can make. The letter was, excuse me, I am not the public, I am staff. So,
At the same time, Mr. Cook, I also believe as a committee, we can make a decision on or the staff report's administrative interpretation and ask that this document, which is well-written, be taken back to town council for decision in a global, community-based way to address any misrepresentation, omissions, whatever it may be called, of the actual Unified Development Ordinance. But we can make a decision for Mr. Payne on a single process, as he is the applicant and we're here to hear his side juxtaposed to what's written in the current regulations.
And if I may, that's also why I was saying that you usually sit to decide on a particular application. My understanding is, as of right now, there is not an application that was submitted that was denied. There is,
So this only goes to council if we can't come to an agreement, in other words?
no, this would go to council independent of whether you come to an agreement.
Oh.
Because the question about whether you're qualified is the fact that as the Board of Adjustment, you don't sit in place of the council. So if the idea is that the council is supposed to make a decision as to how to modify, revise, in any number of ways, the sign code, then you wouldn't make that decision.
We don't want
That is the purview of the council. If, on the other hand, you wish to say tonight that as the language exists now, this appeal is or is not successful, that's what you would do tonight. But you don't have the authority as a Board of Adjustment to substitute your decision in place of council. You are here to interpret what exists and decide how that applies to an application that's in front of you on appeal.
questions.
Now, I heard something out in the audience, but I can't, is there an actual application for this?
I don't believe there is an application that's pending at this point in time.
They won't accept it. We tried. Multiple of us have tried. And I agree, it's not our place to overrule council, but it's not staff's.
if you're going to make a comment that I was out of order, then, follow.
You agree with what?
Both sides are out of the conversation at this point.
Okay.
So I would say the best recommendation is that as you have questions, I suppose I'm the one that needs to answer them to the best that I can, based on what's been presented so far. And I'm only going to be answering as to a legal perspective and not as to facts.
So as we have come to find out, an application has been tried to be submitted, and it's been denied. It
Correct.
seems like several times.
And the issue with that is that we don't have an application in front of you to say, this is the sign that was requested, why it was turned down, and therefore this is an appeal of that denial. So if you had a specific sign, a specific time frame, a specific that, you could make a decision on that particular application right now, but that would not change the existing language. And so most of the discussion tonight has been about how there is an interpretation of what the existing code means. As has been discussed amongst the members of the board, you don't necessarily understand that that is what this says. That is its own telling statement in the fact that you can't have legislation that exists in a sense where it would require people with knowledge of when it was passed to be able to sit there and come back and tell you what it means. You have debates like this at the Supreme Court of the United States when people say, what was the framers' intent?
Yeah.
And then you have these discussions. But when you have them, it's people trying to interpret based on the current language, what was that intended to mean? Not what everyone would like it to mean, not what everybody would like it to change to be. And so it sounds to me like a number of the comments that have been put in front of you are concerns about how the individuals in town, the business owners in town, need this code to read. Well, that's also not something you can decide as the Board of Adjustment. So if you are looking for those types of things to be addressed, those really are issues that belong in front of the council on an overall basis, because those apply beyond any particular application. Those are the global issues that council needs to address in their legislative authority.
Okay, I got lost a little ways back. I thought I was here to talk with our council members concerning Tom and Mr. Cook. One says no, one says yes. And that we vote, that we go yes or no. Is it a yes or no? Is that what we're doing, or?
Well, that's what you should be doing.
Okay.
But if I might say, that's what you would generally do. But the problem is, you are being asked by Mr. Payne to interpret the code globally in a certain way. And so if there were a particular sign where Mr. Payne said, I applied to put in this sign, this writing, this material, this time frame, and then you were to say, yes, that is sign is appropriate. No, there is no application in front of you. And that's exactly my concern with this tonight, is that there is not a particular sign in front of you. So structurally, all you have in front of you is this dueling back and forth between two interpretations of the code. It's not an actual specific application that would be in front of you.
So Tom, the print sign person, would have to put in an application. Mr. Cook would have to say no, and then someone would have to actually take that application that's been denied and then put it in front of us.
Correct.
So Mr. Cook, by default, didn't do that. He didn't take the application that was provided by the person, putting it in front of it. And I'm not saying you're wrong, Joshua. I'm just saying, according to the lawyer, we're supposed to have a document that we don't have.
Right.
And what you have is you have an appeal in front of you as it's written saying, I wish to appeal the interpretation. And so that's the framework that's in front of you.
What I'd like to, the last time we as a board met, it was when the Pet Club was applying for a special provision for setbacks and signage and fencing and everything. They were appealing the code as it was written to have special permission to have a project done. We were able to look at what the appeal was and make our vote based on what was submitted. This time, we have an appeal that is based on an interpretation which we are not qualified to make that decision.
So
That's how I feel.
So I feel like this needs to go to council.
That's exactly what I was trying to get at 15 minutes ago, but then we went on. Now, I appreciate the explanation, but again, that particular point just now is where we're at.
That's correct.
I
That
mean,
is what is in
honestly,
front of you now.
Honestly.
He has
we
a
don't
right
It has
to
to be
apply.
fair
Yeah.
for the town, and it has to be fair for the businesses, and it has to be fair for the look of keep the town, and not all the,
And you stated we're not authorized to do that, so then I guess the next step would take it to council.
Underneath section 1.5, Board of Adjustment 1.5.2, the Board of Adjustment has in their purview the ability to hear and decide appeals from a decision, determination, or interpretation made by the zoning administrator, which is me, in the enforcement of the Unified Development Ordinance, and to reverse or affirm wholly or partly or modify the order, requirement, or decision of the zoning administrator appealed from, and make such order, requirement, decision, or determination as necessary. So it is in your purview to say, A, Tom's interpretation is correct, or B, Mr. Cook's interpretation is correct, or you can say, this is really under the purview of council. Council needs to hear and decide if the temporary sign ordinance needs to be changed at all, what language should be put in if it needs to be changed. These are all decisions, and you can make those you can make it one of those or whatever in a motion.
And actually, I'm going to disagree with you.
Okay.
Because the language that you're reading is specifically meant to apply to a particular action. So if there is a particular permit that is at issue and there is an interpretation of the language by staff, that is what is appealed. There is not a process where a general interpretation of the sign code is what is issued and appealed through this manner.
So,
That is what goes through
So we
council.
have
so
no
the permit that
legitimate
he
appeal.
had technically just opened up a can of worms.
Correct. Correct. And if the council needs to address a lot of these issues because the language as written isn't achieving what the council wants to achieve, then that's exactly what council is supposed to do.
So if Tom were to put in an application tomorrow,
Yes.
and Mr. Cook here turns it down, somebody takes a copy, then
We can
we
appeal.
get it, then we can do
It's
per
actionable.
those two
Correct.
individuals.
And correct. And you would then be ruling on that particular application, not every other potential application under all of that same
I
language.
didn't think I was doing it for everybody else. I thought I
Well,
was.
no,
I was only
I
focusing on
believe
him.
you understand what you are interpreting what this is being brought to you as the way it would generally be brought to you. This, like I've said multiple times, this is not the usual way this is brought to you. As Ms. Duffy was also saying, you had a particular action in front of you last time, back in 2015. You then had the ability to make a decision on that applicant, that application. Where here, this is the general way that the code is to be interpreted based upon the language that exists.
So it's a premature interpretation because we don't necessarily have a denied application.
Well, if you have
We
a
do.
denied
We do have a denied
application,
application.
then that would be the actual appeal.
But his appeal says, I want to apply for a new temporary permit, a new permit. I don't see a denied permit before me. Do we?
That's correct. As of right now, you have the appeal of the desire to apply.
That's correct. Does he have the right to apply for a new temporary permit for a new temporary signage?
So, Mr. Cook, if you were to deny a permit, would you take the actual permit and put a denied?
If I denied it, he could say that he would appeal that, and that would come to the Board of Adjustment.
Okay, so that's where we're at. Right now, that's where we're at. So now we actually have something. Would that be true, Mr. Wood?
No, it's
No.
not true. You don't have an actual application in front of you.
But there was
I don't
one.
have a denied application. I have a
Right.
request for a new permit.
Correct.
Was there a denied application, Mr. Cook?
There have been requests for signage from businesses that have had their 6 months.
Mr. Payne, do you have a denied?
I am not aware whether he's applied or not. I'm not.
So
in
we
the
have no
purview to know
denied permit to appeal,
that. My staff takes in the applications, so
but we have an interpretation of a letter starting in June of 2019.
my understanding from the language that's in the code would allow the interpretation and the appeal of my interpretation in general.
And I disagree.
Well,
So what happens if we
again,
were
the
to
code
do it with
needs
your
to be changed to
disagreement? In
reflect that.
other words, if we were to vote on it
So
and we kind of disregarded your, not bad, but if we disregarded your, what would happen? Is there going to be like, are we going to get sued? Is the city going to get sued? Is Mr. Payne going to get sued?
I can't answer as to whether anybody's going to get sued, but what I can say to you is that if you were to rule on the general interpretation, no one else but Mr. Payne would be allowed to rely on it, as he is the only one that is applied in front of you on an appeal. So if you made a ruling, you would only be making it for Mr. Payne.
But
You
now
would
if
not
some-
be able to make any statements that
Broad
would
statement.
apply to anyone else.
Absolutely, but now if someone else wanted to do a permit that was denied, they could appeal it through that and use Mr. Payne's as a precedent.
No,
If we-
they would need to come to you with
Well,
that
that's what I mean.
application, and they would need to present that application in front of you.
And they could reference our previous,
They could reference it, but they need to actually go through their own appeal process.
okay, yeah,
But in
So-
that time frame, would the town council, the city planning, update the?
Address the issues.
Yeah, update the ordinances and this is like a one-time only because they need to put this on the schedule to get updated.
And that would depend on the council. So if council didn't take action, then it might be that multiple people come in front of you and apply multiple times
For
to
exceptions
appeal
and variances.
to
So-
appeal multiple times and either seek a variance or an appeal of their denial.
And then we would appeal to the town council. I'm kidding.
My question is the applicant before us, is he appealing the fact that his application was denied, or is he appealing the interpretation of the code?
And that's where the best that I can rely on is the actual statement of the applicant that says, I am appealing the interpretation.
And by virtue of that, if we approve his appeal, we are saying that we agree with his interpretation of the code.
for his permit.
For his permit.
His permit,
For his permit.
not any
Not for
other
anybody else.
business.
Which doesn't accomplish anything then.
We need to, I think
Accomplish
we
it
need
for
to send
Mr.
it to
Payne.
council. And let them,
I like to take little bites. I mean, if Mr. Payne is what I'm here for, which is really what I thought. I mean, love all you out there, but I didn't really know that it was gonna be for every single person. I understand, but I mean, it was about this one particular,
It
I need
is.
to stop that. You've stopped public comment.
Okay.
So
I'm
the
sorry.
discussion needs to be between the board members.
Right.
I understood that was, for only one person, my bad.
Can we vote with a recommendation that an action by the council be effectuated within X amount of time?
You could, I would recommend that you potentially separate them out. So in other words, you could take more than one action. You could say, the appeal that is in front of us is resolved this way or that way. And then I think you could also, again, the reason I say that is because you might not have the same number of votes for the combination as you do separately. So I would recommend that you consider the resolution of the appeal, and then you could also say, and the Board of Adjustment moves to recommend X. And then that would be a separate motion in case that one doesn't pass on a different, or has a different vote than the appeal.
Okay.
I move that we vote in that Mr. Payne's interpretation was correct, and that he should be allowed to have his application approved
Which application,
well-
sir?
for his temporary sign.
Which temporary sign, sir? That's exactly the question.
A new temporary
so
sign?
now, you're saying which temporary sign, which application, where's that application at?
Yes.
How many permits did how many permits were applied for? Oh,
I-
no, you would have to talk between you two. I can't talk to you directly.
Okay.
Technically, you can talk to staff and ask staff.
Okay.
Staff is not part of the public, so when the public comment is closed, the public,
Who are the staff?
when the public comment period is closed, that doesn't mean staff can't
Okay.
offer advice, and
Okay.
the attorney can correct me here if I'm wrong as
That's
well.
correct.
Okay.
That's correct.
I move that we vote on whether or not Mr. Payne can apply for a new temporary permit to advertise new products and services that his company has recently added based on the letter of the law as it is written today. And Secondarily, the backup is then I also make a recommendation that we vote that the zoning administration interpretation as presented by the staff be taken up by the town council promptly.
So you need to break that apart.
Yep.
So the first part was a motion,
Yes,
and then there needs to be a determination if there's a second of that motion.
okay.
I second the motion.
Okay? Is there any further discussion on that particular motion?
The first part of the motion is allowing Mr. Payne to apply for a new temporary permit to advertise new products and services that his company has recently added based on the letter of the law as it's written today.
That's what was seconded.
I call for a vote. All those in favor say aye.
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 Aye. Those opposed say nay.
Nay.
Ayes carried.
Ayes carry. Secondarily, I propose that this committee make a decision to reference all staff-prepared information and submit it to town council for important consideration of revising of the Unified Development Ordinance based on appropriate language, missing information, omissions, or whatever's not there to help clarify what is appropriate or not appropriate
As soon as possible.
as soon as possible.
I second.
Third.
All those in favor?
Aye.
Aye.
Opposed? Motion carries. I hope somebody over there. Who's taking the minutes, sir?
I have no
Because
idea.
I
ma'am.
wasn't.
They're being recorded.
What's that?
I didn't know what I was doing, so.
Excuse me, the meeting is not over. If you wish to discuss and cheer and clap and whatever you want to do, can you do it outside while we finish the meeting? Otherwise, if you don't mind just waiting till we close the meeting, that would be great. Thank you. The meeting is being recorded both by audio tape and videotape.
Thank you.
So minutes will be put together.
Okay.
Thank goodness for that because I didn't get all of those two motions. So if we can proceed.
Okay.
The
Number
chairperson.
7, any unfinished business? None being recorded. Any new business?
I do have some new business to discuss. We, since the board has not been meeting on a regular basis, I thought maybe we could discuss times that would be effective, maybe set up a regular schedule to go through training, both on what's in the zoning ordinance as well as protocol, so that the meetings can run smoothly and we can discuss motions and how Robert's Rules of Orders work, things like that. If that is something that you would like us to do, I can bring to our next meeting, maybe in 2 months or 3 months, however, whatever schedule you want, we can start to discuss that. So if you want to discuss among yourselves when you want to hold the next meeting, and if you want training, things like that, let me know.
I think that'll be great.
Definitely.
Definitely.
We
Yeah.
have to make a motion for that?
Not really. You just need to come to some sort of consensus,
Okay.
and then you can direct staff to schedule the next meeting based upon that consensus of when you'd be available.
2 months, 3 months, put us right in the middle of the holidays, November,
Yeah.
December. How about if we agree on January?
Good for me.
Agreeable.
Agreeable?
Yeah.
January, okay with you?
Okay, I will put together a training list of things that we can discuss at that meeting. At this time, there won't be, that I know of, anything that would be brought before you at that meeting other than the training.
And thank you.
So
Is this open for the public conversation as well, input?
No, this is not public. This is just discussion between staff and for new business.
All right. Number 9, any announcements?
Staff has no announcements.
No announcements. Public comment, anyone in the public wish to bring something up that is not currently printed on the agenda?
I would take that as a yes.
My name is Corey Mendoza. Because your duty as an appeals board could be, like tonight's was, between the public and with town staff. I would like you to actually go through the town manager and find out as far as any future training, so that there isn't a conflict of interest further down the road, that you're actually being biased by getting your training from somebody you could, have to decide against.
Thank you. Appreciate it. Any other comments of items not currently printed on the agenda?
Can you, I
Please.
can't hear you, sir. I need you up here.
I'm William Nichols from the CBD Connection. Am I going to be able to present a new application Monday, since Friday everything's closed?
I think Monday's closed
Yeah.
too. It's
Actually,
Columbus Day.
Columbus
if I
Day on
may-
Monday.
I'm sorry, if I may, you can't interact
Oh, sorry.
with the call to the public. So if the one, you could say is you could say, you're welcome to contact staff. You could say, we direct staff to get in contact with you, things such as that. But in a call to the public, it's not generally a conversation with those that are making a presentation. Otherwise, it would be off the agenda discussion.
In all honesty, I think you should call the staff or somebody, because I don't know.
Thank you.
Okay.
Any other public statements? Thank you. We are adjourned.
Actually, in order to adjourn, you need to make a motion to
Yes.
adjourn, second it, and then vote on
I
it.
second.
Okay, we have a second.
I move.
Aye.
Aye.
Aye. We'll look
Okay.
forward to that training.
Good catch. Because yes, you could potentially be in a situation where somebody doesn't want to adjourn.
She is the vice chair. Yeah. Beverly said yes. She volunteered.